Good morning, good afternoon to all our speakers and participants from the EU and Southeast Asia. This is Cory Marshall, and I welcome you to our virtual workshop on geographical indications. This workshop is organized under the IPK Southeast Asia project. The IPKC is a project directed by the European Commission and implemented by the European Union Intellectual Property Office, or the EUIPO. So without further ado, I would like to call on Mr. Raimundo Serra to deliver his opening remarks. Mr. Serra is the Deputy Head of Unit of Asia and Australasia of the Directorate General for Agriculture and Rural Development, or DGI. Raimundo, you have the floor, please.
Thank you, and good afternoon, everyone in the Asian space, and good morning, everyone in the European space. I'm delighted today to share some opening remarks with you all on a topic, the geographical indication and the protection of geographical indication, which is very important for the EU, for the EU Common Agricultural Policy, and on a personal basis, very dear to my heart, as I spent more than 15 years of my career defending geographical indications at international level. I would like to congratulate the project IPK Southeast Asia for organizing this workshop and for the work they've been doing so far in the region, which is very precious and very appreciated at EU level. This project is a very useful tool to promote intellectual property rights in general and geographical indications in particular in the Asian region. I would like to thank all participants to today's seminar, all the speakers for their contributions that will surely bring relevant information to demonstrate the strong benefits of GIs and the fact to have a solid legal system for their protection. We stem from a very strong EU GI system that has been indeed a real success story in Europe as an important instrument for rural development, for job creation in regions, in particular in rural regions. GIs are part of our cultural heritage, and they do valorize the traditional knowledge, the traditional know-how. And behind each and every geographical indication, there is a lot of work. There is a serious commitment to preserve its characteristics and quality. And this is to the advantage of certainly producers, but also consumers that do trust and distinguish quality products. And by doing so, they help producers to market their product better. And that better is very relevant. GI schemes, according to our studies, bring value added to products. We estimate that a GI product is valued on average more than twice that an equivalent non-GI product. And this has resulted in a very significant contribution to the EU economy. Today, the GI sector represents a sales value of more than 77 billion euros and some 15% of the total EU food and drink exports. So it's a very relevant component of our system. The benefits of international protection of GIs are well known. By protecting local value at the global level, we managed to prevent the fraudulent use of protected GI names and then preserve their quality, their reputation that are attributable to their geographical origin. The protection of GIs internationally avoids consumers to be misled by imitations on the market. And by protecting GIs, consumers, business operators can trust and distinguish authentic products from their copies. In recent years, several Asian countries have realized the importance of having a solid GI system to allow producers to enhance their positioning in the global value chain. They've built solid systems of protection. Most of the Asian countries have engaged in that process, establishing the respective IP regimes, revising existing laws, joining international IP agreements, and providing more and more efficient tools to consumers and to producers to defend their rights. In this context, the EU, through the IP's KeyC project, will continue to collaborate with our partners in Southeast Asia to further enhance the global IP system. You can really count on the EU on sharing our best experiences on how public policy can support the development of geographical indication, their protection and their promotion. I wish you today a very successful workshop. Thank you.
Thank you very much, Raimundo, for your time. I would like to request Mr. Ignacio de Medrano Caballero, Head of Service of International Cooperation of the EU IPO's Institutional and Cooperation Department, to deliver his remarks. Iñaki.
Thank you, Cory, and good afternoon to everyone in Southeast Asia, and good morning from colleagues here in Brussels or Alicante. Yes, and thank you for the program to invite me to do this preliminary and opening remarks, which I would start saying that we have seen how intellectual property systems evolve in different parts of the world, an impact of innovation and technology in our lives. Something that it's been quite important here at the EU was 3 years ago, we released a comprehensive intellectual property action plan designed to leverage on the strengths of the EU's IP framework. GIs was part of this action plan, of course, as one of the IP rights that it is, as Raimundo highlighted, very important for the European Union. And it decided, according to this action plan, to strengthen the protection of the GI system for agricultural products to make it more effective and evaluate the feasibility of the EU-level protection for GIs for non-agricultural products. This has already have some impact, as a legislative proposal to protect craft and industrial products was adopted by the Commission on 13 April 2022. Under the proposal, the European Union Intellectual Property Office, the EU IPO, my office, will have some responsibility over the registration of geographical indications for craft and industrial products at the EU and international level. These developments in the EU and the recent changes in the GI regimes in Southeast Asian countries like Malaysia and the very recent one on Philippines reflect the importance of GIs in the European Union and in Southeast Asia, and the need to continue to develop and evolve into more efficient and transparent systems. The activities of the IPK Southeast Asia, as it was also highlighted by Raimundo, are designed to support the efforts of the EU and Southeast Asia to strengthen their respective GI systems. This activity may be classified into 3 types: development of legal frameworks for the establishment and enhancement of sui generis GI regimes in Southeast Asia, something that we have been doing, for instance, in Philippines, and also supporting a possible future system in Brunei Darussalam. Secondly, soft advocacy and promotional activities that support the development of a stronger sui generis GI regimes in the region, improve compliance with the strict standards of GI control, and promote the need for a stronger GI control and enforcement mechanisms to improve national GI systems following EU standards. And finally, awareness-raising activities on the benefits of the sui generis GI systems, the need for a strict control mechanism to assure the quality of the products, enforcement of GIs, and other topics of interest that are identified by stakeholders in the EU and the Southeast Asian countries. The current annual work plan, the one for this year on this second phase of IPK, includes a number of activities. Just last month, IPK was collaborating with IPOFIL in the Philippines, the IP office in Philippines, in organizing the National GI Forum, which served as the launch of the new sui generis GI system in the Philippines. A very important success story for the Philippines to finally, after many years, to have set up this sui generis system in the country. The forum also showcased the first GI protected under this system, the famous Guimaras mangoes. The virtual workshop this afternoon features the recent developments on GIs in the EU, the issues facing EU stakeholders on the protection of GIs and enforcement of their GI rights, and the latest developments in the implementation of the Malaysian GI Act of 2022 and current revision of the GI Act in Thailand. We are also pleased to be part of the 20th anniversary celebration of the GI Law of Thailand on July 20th. This is a very important milestone and is a testament of the strength of the very strong system of GIs set up and developed in Thailand, with so many geographical indications protected in Thailand. We are also organizing a presential high-level study visit for our Southeast Asian partners this month. This will take place back-to-back to the General Assemblies of WIPO in Geneva, and we will take the opportunity of the presence in Europe of our Southeast Asian colleagues to have this study visit from Geneva and some GIs in France. We will continue to collaborate with our partners in Southeast Asia in the enhancement of the GI regimes that benefit both producers and consumers, and at the same time contribute to agricultural sustainability and countryside development. Thank you. Cory, the floor is back to you.
Thank you very much, Iñaki, again for joining us this afternoon, our time. Thank you. So a few reminders before we begin. Interpretation is available in Bahasa Indonesia, Malaysian, Thai, and Vietnamese. Please click on the interpretation icon at the bottom of your screen. Most of you know this already. And you may send your questions to us using the Q&A icon, also at the bottom of your screen at any time during the presentation. So I will be reading one question at the end of each presentation if we have time, but most of the questions will be read towards the end of this workshop. And at the end of this webinar, we will be sending survey questionnaire, and we would appreciate it very much if you would respond to the questionnaire. It's our way. It will help us improve future activities of the IPK Southeast Asia. So we start with the first presentation this morning, which will be delivered by Ms. Katarina Baratova, Policy Officer at DG Agri. So she will present on the recent developments in the protection of GIs in the EU. Katarina, I turn over the floor to you.
Thank you very much, Cory. Good afternoon to all the participants from the Southeast Asia. And also good morning to the colleagues and participants from the European Union. I am very happy to be here today to join you in this very interesting event. And I would like to guide you through the most recent developments in the protection of geographical indications in the European Union. So yes. As Raimondo already said at the beginning, the geographical indications are a real success story in the European Union, but also from the international point of view. In the European Union, we have a really well-functioning and sound system, which is also not only reflected in all the benefits and advantages that are generated first and foremost for the producers, but from our side, we see the continuing success story in the rising number of registrations. This year, we reached the new milestone when in February, we registered the geographical indication with number 3,500. And at this point, when we are at the end of June, this number is already higher. We have now more than 3,520 geographical indications registered. On this slide, you can see the distribution. You can see that for food and wines, the number of GIs registered is quite well balanced. So it's a very similar number. And then we also have 260 spirit drinks registered as geographical indications. And apart from this, we also have 1,752 geographical indications from non-EU countries that are protected in the EU under the bilateral agreements. And because today the focus of this event is the region of Southeast Asia, apart from the fact that on this slide you can see the distribution of geographical indications registered among the European Union member states. You can also see here that under our sui generis system, we have 226 geographical indications registered from non-EU countries. And when you look at the leading European member states, I think it's no surprise that countries Italy, France, and Spain are leading in the number of geographical indications registered. And on the following slide, you can see some statistics from the region of the Southeast Asia. So overall, we have 9 geographical indications that are registered and protected through direct registration in our sui generis system. You can see also the distribution of GIs according to the countries from the Southeast Asia. And on the top of this, we have also 39 geographical indications from Vietnam that are protected under the trade agreement. But when we talk about really the most recent developments in the protection of geographical indications in the European Union, the most important topic to talk about is our proposal for the reform or revision of the current system of geographical indications. As I said, we have a sound and well-functioning system of geographical indications, but because of some recent developments in the recent years, and also because of some challenges, there are always the rooms for improvement, and that is one of the reasons why we came with the revision of geographical indications. And the main starting point for this reform were basically 2 initiatives that were adopted at the EU level in 2020, which represent also a strong link to geographical indications. So it was a farm to fork strategy, which is a comprehensive strategy for the food and agricultural system at the European level. And this strategy calls the European Union to strengthen the legislative framework for geographical indications. And apart from that, there was also intellectual property action plan that was adopted in 2020. And as it was already mentioned by my colleague Ignacio from EUIPO, this intellectual property action plan calls the European Union to improve the protection system for agricultural geographical indications, to make the system even more effective and specifically more effective in fighting the infringement of geographical indications. And this intellectual property action plan also calls the European Union to establish the new system for non-agricultural geographical indications, thus for crafts and industrial products. However, this new system is not in the remit of the DG Agri, but it's under the competence of our colleagues from DG Grow, which is the Directorate for Internal Market, Industry and SMEs. The overall objective of the proposal for the legislation, for the new legislative framework of geographical indications is to strengthen the existing system, to increase the efficiency of this system, and eventually to increase the efficiency of the whole registration process. This proposal was adopted by the European Commission already last year at the end of March, on 31st March. And this adoption was preceded by the very comprehensive policy evaluation and analysis, based on which we determined 6 specific objectives for this proposal. So as you can see on this slide, one of the objectives is to strengthen the protection and enforcement of geographical indications, with strong focus on internet, because we see in recent years the huge development of e-commerce. And with that, unfortunately, it's also connected the rising infringements of geographical indication rights on the internet. Then the proposal also aims to encourage geographical indication producers to incorporate sustainability aspects. Then another objective also connected with strengthening the position of producers is empowering the GI producer groups to basically achieve the better management of geographical indications as IPR rights. With this new revision, we also aim to increase consumer awareness of geographical indication schemes and logos. Overall objective is, as I said, to streamline and clarify the legal framework. And under the current system of geographical indications and under the current legislation for geographical indications, also the specific framework for traditional products is included. It is traditional specialties guaranteed. And under the revision of the GI system, this framework will be kept, but the revision will bring some clarifications also to increase basically efficiency of this scheme. I would like to point just the most important novelties of the proposal that are connected to these specific objectives that I have just mentioned. So first of all, what is a novelty in our geographical indications legislative proposal is the extended scope of the new regulation. The revised geographical indication system will be aligned with the definition of agricultural product according to the WTO definition. So it means that the new system will cover wine, spirit drinks, and agricultural products that are listed in the combined nomenclature in the chapters 1 to 23 of the Common Customs Tariffs. Then the proposal aims to bring the harmonization to the system of geographical indications. And this harmonization will be mainly reflected in the procedural rules. You have seen at the beginning of my slide of my presentation the divided statistics for 3 sectors, because we have 3 sectors: wine, spirit drinks, and food and agricultural products. And basically each of these sectors have a specific legislative act, and in each act there are procedural rules that are established. And although the framework is more or less the same, there are still some small differences. So with this revision, we will bring the common provisions on the procedures to register a geographical indication name, the common procedure to amend the product specification, and also the common procedure to cancel the registration of geographical indication in all these 3 sectors. Then another important element of the legislative proposal is increased protection of geographical indications, as it was called upon the EU to do so in the Intellectual Property Action Plan. So also in this regard, the proposal is aiming to bring further harmonization. So the provisions on the protection will be common and for all 3 sectors, and they will be established in one act. And the proposal, as I said in the beginning, one of the challenges that geographical indication system is facing now is increased sales of geographical indications through the e-commerce, and with that are connected the increased infringements of geographical indications. So the proposal also brings increased protection as regards the online sales of geographical indications. And when we talk still about the internet, there is another novelty that is brought forward by this proposal, which is protection of geographical indications in domain names. So our proposal brings specific provisions for country code top-level domain name registries that are established in the European Union to revoke or transfer a domain name that is infringing geographical indications. In practice, it means that these registries will be obliged to recognize in their alternative dispute resolution procedures for disputes in the internet also geographical indications, because what we see currently in the European Union when there are these procedures determined by country code top-level domain name registries, they are in most of the cases limited to trademarks. So if someone in the EU register your geographical indication as the domain name, you have no other way to get this domain name or get it cancelled than to go to the court. And the proposal also aims to create the information and alert system. This information and alert system would basically inform the applicant when applying for geographical indication about the availability of his geographical indication as a domain name. So this is really to inform the applicants about the opportunity to also think about the registration of their GI as domain name in order to avoid abusive registration by someone else at the later stage. And this system would be operated by EU IPO. I mentioned at the beginning the farm to fork strategy, which among other things talks about the sustainability issues in the European agriculture. And what we have seen when we did the evaluation of our current policy for geographical indications was that the consumers think that sustainability is not enough reflected in the geographical indications. So that's why this proposal brings forward the sustainability undertakings on a voluntary basis. This means that if the producers of geographical indications agree on some sustainability practices, they can do so, and they can decide to put them directly in the product specification. And when the sustainability practices are included in the product specification, they will be automatically subject to controls. And with the aim of further strengthening the position of geographical indications producers in the European Union, the proposal also introduces the concept of recognized producer groups. These recognized producer groups would be designated by member states, and they would be granted with more powers. This is notably to give the producer groups the power to liaise with anti-counterfeiting authorities and take enforcement actions. Apart from these novelties, another novelty is the provisions on controls. This is another area where our proposal brings further harmonization, because it introduces the common provisions on the controls for spirit drinks and agricultural products. But the control provisions for wine will remain to be defined in the Common Market Organization regulation, and this is because of the specificity of the wine sector. And the proposal will also introduce the certificate of authorization to produce. This is already existing measure in the sector of spirit drinks. So it will be, with the new reform, it will be also in place for agricultural products producers and the producers of wine. And basically, this measure means that the producers of geographical indications will be entitled to have the certificate that is basically the proof that they can produce the geographical indication because they produce in line and in compliance with the product specification. And this kind of certificate might be very useful, for example, when selling geographical indications to the supermarkets, to the restaurant, because the producers can prove and can submit this certification to the supermarket or restaurant. But also it is very important in the relationship with the enforcement authorities, which can sometimes ask for the proof of compliance with the product specification. And one of the most important novelties, and I would say the flagship measures of this revision of geographical indications is technical assistance by EU IPO, because our proposal foresees that EU IPO agency would assist the Commission in the scrutiny of the applications for geographical indications, their publication, and also the opposition procedure. This is all to achieve the objective of increased efficiency of geographical indication system and to reduce the registration time for GIs. But here I would like to really emphasize that it will always be the Commission who will be responsible for the geographical indication policy, and the final decision for each and every geographical indication application that will be submitted will be done by the European Commission, by us in DG Agri. And the last measure I would like to mention is the single committee for geographical indications, which will be introduced with this revision. This will help us also with the faster adoption of the Commission implementing regulations, registering the names or approving the amendments to the product specifications. So all these novelties that I have talked about are the novelties that were introduced by the European Commission, and it's basically the wording of these novelties, as you can find in the proposal that was published last year by the Commission. But as every legislative proposal in the European Union, our proposal is also the subject to negotiations with the European Parliament and with the Council. So on this slide, you can see the current state of play of our legislative proposal. So after the proposal was adopted by the Commission last year, we started the negotiations in the Council, where we have been discussing the proposal with the representatives from a member state that are dealing with geographical indications. And the result of this process was that the Council also introduced some amendments to our legislative proposal. At the same time, the European Parliament has been looking at the proposal, and they also came up with some amendments. And all these amendments and the initial proposal from the Commission represent the starting point of the negotiations, what we call the interinstitutional negotiations. And these have just started at the beginning of this month. And the plan to reach the final agreement and approval on the final text on our legislative proposal is planned for the end of this year. And once the legislative proposal will be agreed, it will enter into the force after its publication. And then our regulation will start to apply 1 year after it will enter into the force. And because one of the most significant developments in geographical indications area is also the introduction of the new system for crafts and industrial products, I would like to also say a couple of words about this proposal Although, as I said at the beginning, it's not DG Agri that is responsible, but it's our colleagues in DG Grow. But I think that this proposal might be of interest to you as well. So this proposal was adopted shortly after our proposal last year on 13 April 2022. But this proposal has a bit different timeline, which is the reason why our colleagues in DG Grow are already more or less at the end of the whole process, because they already went through the interinstitutional negotiations with the Parliament and with the Council, and at the beginning of May, they reached the provisional interinstitutional agreement. And now they are just waiting for the final vote by the European Parliament and by the Council, which is expected at the end of July. And then the new legislative framework for crafts and industrial products will start to apply 25 months after the proposal will enter into the force. The proposal is, of course, a bit different, and some provisions are a bit different than the provisions in our case, but this stems from the nature of the product. But there are also a number of provisions which are very much aligned with our system of geographical indications, because our system, since it is well established and well functioning, was also taken as a model for crafts and industrial products. And here I would like to end my presentation, and I thank you very much for your attention. And if you have any questions, please don't hesitate to ask or put them into the chat. Thank you.
Thank you very much, Katarina. So we have a couple of questions, but I will read just one right now, and I will read the other questions later. That's okay with you. So first question is, does agricultural products include tobacco products?
No, tobacco is not included under the current framework for geographical indications, and is also it will also not be included in the new framework. And the reason for the exclusion of tobacco is because of the health reasons.
Thank you very much. I will read the other questions later towards the end of the webinar. Thank you again. Our next presenter is Mr. Muhammad Azrul Abdul Hamid, who will discuss the issues affecting the protection and enforcement of GIs. Azrul is with the IT Committee of Eurocam Malaysia and is a partner at Azrul Liu and Company, or Alico.
Yeah.
Azrul.
Thank you. Good morning and good afternoon, everybody. So I'm a practicing lawyer, and I'm in the Eurocam IP committee as well. Today, I'm going to be talking about issues affecting the protection and enforcement of GI, especially three particular topics, which is in relation to coexistence of GIs with prior trademarks or trademarks, control of GIs to ensure quality, and in enhancing the level of GI protection. I won't go so much into what is GI, etc., because I think my colleague from the My IPO will be talking about this. In Malaysia, we actually have quite a number of GIs registered in the register, I think about 170 or something. And it's mostly for local products. And there's only a few foreign GIs that are currently registered in Malaysia. And of course, one of the more famous one is champagne. But of course, in Malaysia, we have a lot of very famous GIs as well, like Sarawak pepper, a lot of from the East Malaysia. I will skip this part. I think Mr. Raizul will talk about it. But in essence, I would just like to say that in Malaysia, we have a GI Act since at least the year 2000. And recently in 2022, we repealed the old act, and now we have a new GI Act in Malaysia that is extensively enhanced. And just briefly, this is I obtained this chart from the My IPO. When it comes to applications for GI, there is a stringent examination formality that an applicant would have to go through. And if that is allowed, it will go through advertisement, and it is now open to opposition as well before the GI is allowed to be registered. And of course, you can appeal the decision of an opposition to the Malaysian High Court, which is the first court of instance for matters in relation to intellectual property. So for the protection of GI, geographical indication is specifically protected in relation to regardless of whether or not the geographical is registered as against another geographical indication. And the benefits of having a GI registration, is that it is a prima facie evidence of the ownership of a GI. So in this sense, it is equivalent to how you have a registered trademark when you have semi-criminal or civil proceedings. There is less thing that you would have to prove if you have a registered GI in Malaysia. And also similar to a registered trademark, when you have a registered geographical indication, it subsists for 10 years and can be renewed for subsequent 10 years and so on. So in relation to the control of GI to ensure quality, this is provided for in the Act that it has to be, when you make an application for a GI, you have to show that what is the reason that you make this application, and why is it that that particular GI has a particular quality in relation to that particular area. So it is a statement you make in your application form. And this insurance of quality goes through an examination process by the Malaysian Intellectual Property Office, and they would ascertain whether this particular GI has the necessary qualities for it to proceed to a registration of the GI. As I mentioned, there is quite a number of GI registered in Malaysia, especially for products in Malaysia. And I noticed that it is in a lot of these application has been conducted more by the state government authorities. For example, in Sarawak, I think the Sarawak state government takes a very active measure in making a lot of applications for products that originates from Sarawak, where Malaysians do recognize that a lot of this product have a particular quality coming from that particular area in Malaysia. And I've seen some also applications made by the state government link company in Malacca, which is a state in the southern part of Malaysia where there's a lot of GI applications as well. So in relation to the control of the GI, it goes through a very stringent examination process. I think Mr. Rizal will perhaps explain a bit about this, of how they examine applications for GI in Malaysia. So the big question for Malaysian GI, intellectual property practitioners, is that what happens when a GI coexists with an existing trademark, or what happens when a trademark uses a GI as a trademark, right? So in Malaysia, this is specifically prohibited in the Old Trademarks Act and also in the New Trademarks Act. When it comes to making an application for a GI, if or an application for a trademark, it is specifically prohibited for a GI to be registered as a trademark. This is in the Trademarks Act 2019, where it is in the previous act, there was no provision to indicate that it is a strict refusal of registration. But in the new act, the Malaysian government has indicated that when it comes to trademarks that contains or consists of recognized geographical indications, if an application is made to the Malaysian Intellectual Property Office, the registrar will not allow for such geographical indication to be allowed to be registered. And in essence, if you have a geographical indication and you make an application for a trademark lawyer would usually advise the client that such a trademark would usually be objected to when you make an application for the same, right? So usually we will not advise you to do so, because the right provision for you to protect a geographical indication is under the Geographical Indications Act. And we have two cases in Malaysia that talks about this point. The first case was a case that was decided in 2011. This is before the new Geographical Indications Act 2022. This particular case, it did not really refer to it is relying more on the old act of the Geographical Indication Act, also the Trademarks Act. So what happened in this case is that there is this company in Malaysia that made an application for to use the pony mark as a trademark, and a body which is the body that is tasked with, amongst others, the development of the Indian rice industry, which is from India, APEDA, and a company that is engaged in the distribution of this ponies rice in Malaysia, in India, took an action against this Syarikat Faizah Siram Berhad, who has obtained the registration of this pony trademark in Malaysia. So what they are saying is that they argued that the word pony is not supposed to be, in essence, is not supposed to be registered as a trademark because it is descriptive of a particular variety of rice originating from southern India. And in Malaysia, we know this, there is evidence that shown that they have started to use this, disputed this pony rice in Malaysia since before the date of the application of the trademark. So in this case, the judge had decided that in cases where the mark is a geographical indication, and there is likely that there is going to be a confusion to the trade and the public with regard to the use of the mark was then expunged from the register, where it is not supposed to be registered as a trademark, where in fact it actually refers to a particular rice for a particular region of India. So it is positive decision for an owner of a geographical indication, where in this case the matter was instituted by the Agricultural and Processed Food Products Export Development Authority. Is an authority in India in relation to food products, and also the other parties that sued the Malaysian entity was people who were involved in the rice trade in India. The other very, I would say, is a very determining case with regard to whether a trademark and a GI can coexist in Malaysia is what we call the Swiss chocolate case. I mean, this is what the lawyers in Malaysia call this case. In this case, it started in the court of first instance. It went up to the appeal court of first instance, and it then went up to the federal court, which is the final appeal court in Malaysia. So it went through 3 stages of litigation, where in the first instance, the plaintiffs in this case were the Choco Swiss Union, or manufacturers of Swiss chocolates. And they are also sued together with companies that have some interest in relation to Swiss chocolates. And this Malaysian company is called Maestro Swiss Chocolates and Berhad, and they are operating in Malaysia using the trademark Maestro Swiss. So of course, it is obvious in this case there is a dispute in relation to the Swiss geographical indication, right? Because I mean, looking at the mark itself, it can be construed that people may think that these are Swiss chocolates, you know, whereas it's not the case because these products were actually produced in Malaysia. So the determining question at the Court of Appeal, there were two causes of action in this case. It is in relation to the cause of action of passing off, and also there was also a question of what happens when you use a trademark consisting of a geographical indication, where in this case is Maestro Swiss, which infers that the chocolates originates from Switzerland, and also when there are also provisions in the Geographical Indication Act in Malaysia that prohibits the use of geographical indications as trademarks, in essence, right? So what happened in this case was that the court found that there is no case for passing off because a society, it was this, I mean, of course, different facts of cases would differ in different cases. I think in this case, it is not correctly decided that a trade association does not have goodwill and reputation in relation to a particular product. Whereas in this, because there are other cases in Malaysia that had decided that trade association can also have goodwill and reputation in relation to products. But in this case, it was distinguished that the Choco Swiss Union didn't have goodwill and reputation, and as such, they did not make a case for passing off. Passing off is another version of trademark infringement. Basically, it's in relation to a claim of trademark infringement for unregistered trademarks, right? So they failed in relation to the issue of whether there is a passing off when they are using the mark Maestro Swiss in Malaysia. But the good thing is that in this case, the court had clarified it is at the federal court. So this is the determining case at the moment in relation to this issue of coexistence between a prior mark and a GI in Malaysia. So in this case, it had clearly decided that if you had used a geographical indication as a trademark in Malaysia after the enactment of the Geographical Indication Act of 2000, which has now been repealed, and with the Geographical Indication Act of 2022, you cannot have a trademark that has a reference to a geographical, you cannot use a trademark that has reference to a geographical indication in Malaysia. So the issue is actually decided very clearly that in Malaysia, if you have a geographical indication in a trademark, after the enactment of the Geographical Indication Act of 2000 that came into force in 2001, you cannot use a geographical indication as a trademark. So if you want to register a geographical indication in Malaysia, and you find that there is a pre-existing trademark that uses a geographical indication as a trademark, you can of course file a suit to rectify the same, in essence, right? So it is clear in the current Geographical Indication Act that there has been a further enhancements in relation to the protection of the Geographical Indication Act in Malaysia. The previous Geographical Indication Act of 2000, I would say, is fairly brief, you know, whereas it has been repealed, and the new Geographical Indication Act now is very comprehensive, and it provides more protection in Malaysia in relation to geographical indications. So in Malaysia, even if you do not have a registered geographical indication, And if you have an interest in a particular geographical indication, you can initiate action against persons or companies that have been using geographical indications as in usual cases as trademarks, right? So in Malaysia, you are not allowed to use, I mean, it is stressed again that you are not allowed to use a trademark as a geographical indication. And if you now, if your foreign company would like to come into Malaysia to register a geographical indication, and you find that there are other entities in Malaysia that are using geographical indications as a trademark, you can file a suit in Malaysia. Or alternatively, this is to stress how the Geographical Indication Act in Malaysia has been enhanced in the protection of geographical indications in Malaysia. They have included a quasi criminal provision in the Geographical Indication Act of 2022, where now, if you have a registered geographical indication, you have a certificate, and you find that there are persons importing and selling any goods falsely applying the geographical indication, or they have been falsely submitting false information to the Geographical Indication Office, or falsely representing a GI as a registered GI, and falsely representing the goods as being for which a GI is registered, then you can make a complaint to the authorities for action to be taken. And this is an administrative action where criminal case can be made against these offenders of the geographical indication. The ministry that deals with this is the Ministry of Domestic Trade and the Cost of Living currently. And of course, there are fines that you can either be fined, or you can also they also have sentences of imprisonment for people who have been sentenced in court for offences against the Geographical Indication Act. But in most cases, I suspect that a compound, which is just an administrative fine, would be made against parties that are found to be, offending these provisions of the Geographical Indication Act. Okay, basically that's it. I try to, because I think I'm also running out of time. But if you want, I can briefly share with you a list of some of the geographical indications that we have in Malaysia at the moment. I think it's not a very long list, but as you can see here, most of the registered geographical indications are from local entities, and it is supported a lot by the state governments in Malaysia. And of course, we have a few like the Scotch Whisky Association. Champagne is registered as a geographical indication in Malaysia. And also we have tequila. Tequila is also registered as a geographical indication in Malaysia. So that's it for my talk. I think I'm within the time scope. So are there any questions, Ms. Krazan?
At the moment, we have no questions, but
Yes.
I believe we will have questions later
Okay,
towards the
thank you.
end of the webinar. But I'll
Okay.
read the questions later on. Okay, thank you
Thank
very
you.
much.
Thanks.
Thank you, Azrul. Our next presentation is also from Malaysia. Mr. Raizul bin Osman Basa. He's an intellectual property officer from the Intellectual Property Corporation of Malaysia. And he will present the issues and challenges in the implementation of the new GI Act of Malaysia, which was enacted last year, 2022. Raizul, you have the floor.
Hi, everybody. Good afternoon and very good morning to all of our participants and speakers and organizers. Firstly, I would like to thank to the organizer and the participant for this kind of invitation for me, Raizal Osman Basa from Malaysia, specifically from MIPO, Intellectual Property Corporation of Malaysia, to join this event. And my duty here, I will be given a task to share certain information. And my topic is implementing the Malaysian Geographical Indications Act of 2002 issues and the challenges. Today, yeah, a lot of issue prior and after the implementation of the GI Act, our new GI Act. But of course, it's not the perfect act, but we must live with that and we must move forward. And we need to tweaking and make some adjustment here and there. Okay, my content for this afternoon, Malaysia currently afternoon, yeah. Sorry, my content for this afternoon is divided by four subtopic. First, of course, geographical indications. Number two, the background of GIA or GI Act 2022, and certain features of our GI Act, I mean Malaysian GI Act 2022, and some progress, issue, challenges, and of course, we need to find some solution over the issue or the challenge that we face. Yeah? And also, I will share with to all my beloved friends here recent activities. Currently, what we do here. Yeah? Okay, of course. We still use the old Act definition regarding the geographical indication. That, of course, we are mirroring the from the Article 22.1 from the TRIPS. Yeah? Geographical indication means that indication may contain one or more words which identify any goods that originating in a country or territory or region or locality in that particular country, where it's a given quality, cost, reputation, or other characteristics that of goods that essentially attribute to it geographical. Then you may, if you have our act that you can access from the internet, you can refer to our section 2 of our GI Act 2022. And yeah, basically, our what we call our philosophy for our GI Act is first, the protection must fulfill these basic three components. First, an indication meant the thing that refer to, and of course the geographical location, and also the good itself. When you talk about the goods, it must have some very high quality and the standard. Must have a very good reputation, and also we must look the character of the good that must attributable to the geographical origin itself. Yeah. And then, yeah, I will share certain background of our new GI Act. Yeah? Okay, basically, our historical background for our geographical indication law and environment in Malaysia, starting geographical by the introducing Geographical Indication Act 2000, maybe 20 years or more than 20 years, and passed in Parliament in year 2000 and contains several parts of the section and one schedule. Today, I can say, frankly speaking, I can say here a lot of loophole. When we introduced the GI Act 2000, and then in the certain after we do a certain review, certain study, and get some we call it external and internal point of view from the various stakeholders, our GI owners, our enforcement division, and also from our legal fraternity here. Yeah, we come up with our new GI Act, we call it the GI Geographical Indication Act year 2022, that contains 15 parts, 1,000 sections, and one schedule. And this act is tabled and passed by the Parliament in some year, December 2021, and come into force on 18 March of 2022. And also we also introduce and we also do some comprehensive regulation, and also we also introduce guidelines. Actually, our new GI Act is mirroring, I can say, mirroring of our new Trademark Act 2019. I mean the framework, because of course our Trademark Act also have of course the main act, the regulation, and also the guidelines. And the authoritative text in Bahasa. We used our own Bahasa Malaysia as our authoritative text for the act. Okay, why we repeal the GI Act 2000? Because of course now I mean the current trade change within minutes, within hours, within day, within year. So our act must also be changed. And because the first one we want to strengthen, of course, for sure, we want to strengthen the GI Act protection system according to international and the local development needs. Because the business environment keep changing, so we must follow. We must not left behind, and also expand the scope of protection. Introduce a new and comprehensive internal procedures, and also introduce the provision like our beloved friend, my learned friend, Mr. Azrul, a certain provision of offense and criminal jurisdiction to enforce the right obtained under the Act. And of course, we need to expand certain provision that match the scope of the civil action. And number 5, we want to expand the level of protection that given to registered geographic indication in Malaysia, because we receive some not so called complaint, the opinion, the feedback from the GI owner that they say that our GI of 2000 is not enough to protect their product. I mean their GI product. Then number 6, we need to refine the procedure, filing application for registration of the GI indication, including examination, the opposition proceeding, registration, and also cancellation procedures. Okay, what are new features in our new Act? Okay, first, we expand our category of good. In our previous Act, we have 4 classes, but if you look our previous Act, it's not so clear. Let's say agriculture products. What kind of agricultural product that can be protected under GI? Food. What kind of food? And also natural product. What kind of natural product? What kind? So it's not so clear. So my team, our team gets a lot of opinion and also a lot of discussion with our stakeholders. So we come up with we come up with 5 classes, and then after that we specific, not too specific, but enough everybody to understand what kind that product that can be protected under our GI Act 2022. For example, here you can see here, for example, class 1, of course, wine and spirit, very clear. And class 2, prepared foodstuff and beverages. What kind of prepared foodstuff and beverages can be protected under our GI Act 2002? We have tea and rye, bread, pastries, a lot of things. Yeah. And also we have class 3, for example, the agriculture, aquacultural, horticultural products, for example, vegetable product, fruit and food product, meats, raw and unprocessed grains, seeds, flour, and part of flour, we also protect. And also we have class 4, handicraft, and the last one is class 5, textile. Okay, why I put in bracket other than handicraft? Because some textile, they are very potential to register under GI, but they are not handicraft. They've been used as a jacket, as pen, as that means the textile being used every day by the people. So we make a decision that this kind of textile is not for under handicraft. When you talk about handicraft, it must be handicraft. You hold in your table, you hold in your window, for example. This is different. And then after, and then maybe in near future, we will add a new class, maybe class 6, because we found that we miss a natural product over here, natural processes product. For example, you have, what we call the mangrove wood. Then the wood, you create something. Then the wood is it's not handicraft. You make some I don't know the wood itself. You create something. Then you can use for example for food, or you can use for whatever. Then when we look into all these classes, you can't register the wood, because wood is not the agriculture. It's maybe a natural product that you may get from the jungles. You didn't harvest the tree. The tree you get from the jungle. So it's not fall under the agriculture, even not fall under aquaculture. So maybe I will suggest to our top management, to our legal division, to add plastic under goods name natural product. Maybe later on after this. Okay, we move forward. Okay, our application system. Like Mr. Azrul said previously, the person or the applicant that may apply and of the geographical indication is fall under 1, maybe 2, or maybe 3. First, producer and a group of producers. Number 2, the competent authority. Number 3, association that represent the community that the product being produced. Okay, for example, producers. For example, sometimes in the remote area, there's a lot of product in that particular place. But unfortunately, there is no so-called NGOs, association, cooperative, or even competent authority that can represent that farmer. For example, if the GI is a product, agriculture product, the farmer themselves. So what we do is we ask them to list down the name, all the name of the farmers over there as we call it a group of producers. So when they apply GI, they must put the whole name of the farmers in our form, and maybe one of the farmers can sign the form as a representative only. Because we face this problem. There's no cooperative, no association, even no competent authority can represent them. But the GI is there. The GI product is there. Another GI applicant is the competent authority, because sometimes when we go to the certain area, we found that even though there has some association there, or a group of farmers, a group of GI producers over there, but they are not so strong. They are not so strong. They are not so stable. Because of the old-fashioned style of management, I don't know. Then we make a decision that we invite the competent authority in that particular place to be a GI holder, and all the farmers or the GI producers can be as their user, that being permitted by the competent authority. Because of the competent authority in Malaysia, when we talk about competent authority in Malaysia, refer to the government or government agencies, the state government agencies, federal agencies. And also the third one is the association. Let's say we have a lot of the what called association here. For example, we have the durian Durian Association of Malaysia. Durian, you know Durian, Association of Malaysia. Durian Producer Association of Malaysia. We also have what we call Rice Farmer Association of Malaysia. We call it NAFAS. So they may apply. They may apply to, because they are represent the farmers or they are represent the GI producer in the particular area. So when we go deeper, when the MIPO do a due diligence, and we found that they are entitled, they have a right to hold the GI rights that represent to the community in the place. Okay. Second one is the procedure. Okay. With introducing of the new act, the procedure is so simple compared to last time. For example, here you can see here our application form GIA1, and we just ask the location map, product specification, that we call it a book of specifications, and evidence that I apply or protected. For example, if you are foreign application, you need furnish us the form or any evidence that the GI being protected in your country. For example, you are from India, for example. Then you try to apply to secure the protection over here in Malaysia. So we ask you to furnish us evidence. For example, GI certificate from your country. You must submit together with our GI A1 form. Okay. And then if you are represented by our IP agent or GI agent, you need to furnish us a GI A2, and also if your application being approved, you need to finish a GI A7 for the attachment of the application. Okay. Okay, the duration, duration for protection forever, but renewable every 10 years. How about cancellation? And our registration can be cancelled first by the owner of the GI, and also by the court. Someone have been taken this issue to the court and asked the court to invalidate. They may request, but it's up to the court to decide whether the GI can be invalidated or not. Okay, the fee very cheap for the time being. The initial fee for registration for the filing of application is RM Malaysia Ringgit, RM 250, and for advertisement, the GI holder need to pay another Malaysia Ringgit 450. In total, the cost, official cost for application is RM 700 Malaysia Ringgit. Okay, new features. Okay, we have also introducing variant registration. They say you have one GI has been registered, for example, Sarawak paper, and then later on you want to apply under this provision variant GI, the symbol of a Sarawak state, for example, rhinoceros hornbill. Rhinoceros hornbill is the official bird for the Sarawak state, rhinoceros hornbill. And also, beside the rhinoceros hornbill, you also add a picture of the pepper itself. Pepper. So it's also, we can consider it as a variant GI, because the picture of the rhinoceros hornbill represents Sarawak, and the picture of the pepper itself is represent of pepper. So they may apply under variant, GI variant. But this application must be applied by the same applicant or same right holder. And then we have a homonymous GI. Other than wine, last time we only provided for wine, but now we expand to all goods. We need to say, let's say you have rice, you have whatever rice in your particular country, and maybe the other country also would have a similar variety of rice and have a good reputation over at their country. They may apply under homonymous GI. But here we will allow the registration both but we need to add on certain, I can say here, practical condition to differentiate the homonymous, this homonymous GI from the earlier one. Okay, new subject matter. For the GI, I already mentioned, or you may refer to our new GI Act on section 2. And I also mentioned the voluntary cancellation. You may refer to our GI Act section 22. And then we also introduced ground of cancellation by the court. There's some tests and requirement provided. I already mentioned to all of you previously. But if you want to more deeper and specific, you may refer to our GI Act at the section 23. Another thing, last time, our GI Act didn't provide the transfer, whether the GI may transfer or not. So when the Act silent on that, we will say that last time GI can't be transferred, cannot be transferable. But now we under our GI Act, GI holder, our current GI holder may transfer his right to another or to the new holder. They say in this case, it can happen in situation where they say this association is not so stable. The right holder is not so stable, and also maybe in the certain, I don't know, in the certain they have a lot of issues, for example, politics or whatever. Then they think that they cannot hold this right anymore. And also we found that there's another association in that particular area also. Like maybe new that I can say more stable, more capable to hold this right. So the GI right holder may by the agreement transfer his their right to the new holder. Then in detail, you all may refer to our new GI Act on section 26. Okay, number 5, introducing ground as proceeding on the court regard to institute the proceeding against certain use GI as specified under section 77. And number 6 is offense that Mr. Adil mentioned previously. You can refer in our section 34, 35, and part X. Okay, and number 7 is a system agent of GI. Until last time we already had, but it's, like I mentioned previously, it's not so clear. And also the procedure have a loophole here and everywhere. So now we try to revamp. We not try to revamp, we revamp and give some good procedure and give some clear procedure on the our agent system. Okay, now we proceed to the progress, issue, and challenge. Okay, the progress. For the time being, what we do is after introducing new act, we aggressively try to increase GI awareness, and then we put some budget, massive budget, to promote GI through our mass media, internet, social media, print press, some print press, and promoting by promoting GI location as a travel places. And for the time being, after introducing a new GI Act, we currently have a 7 GI application. And number 3, we try to improve everything framework book of specification to all applicants and owner, because not all on GI holder can do and can update their data, the information by using the book of specification. Then from time to time, we approach the GI right holder to update. We ask them, is there any new development for your GI? So we ask them to update with us. And number 4 is talk session. We do a talk session and discussion with owners, applicant, and also our law enforcement department regarding a new geographical indication, including our judge, our court officer. We also have several or series of meetings with them. This is our progress for the time being. Yeah? Okay, issue. This is the most crucial part. I believe that all over country, ASEAN country face this problem. First, the lack of awareness, quality or specificity GI product is the main challenge for the producer. Yes, awareness. Sometimes like the certain our GI holder, yes, they already apply, already get the certificate, but they didn't know how to, I can say, exploit their right in terms of commercial. This is the thing. When we do some survey, we do some survey. Number two is compliance. Yes, I mean this is a refer to the control and quality of the product, especially agriculture product. I believe because Malaysia have a lot of agriculture product, and sometimes they have their challenge is to keep the quality product consistently. So this is the problem, and for the agriculture, we also keep advice the agriculture department, Malaysia agriculture department, to assist us to maintain, to keep assist us and assist the farmers or GI holder to help them for whatever problem they face during when they develop or when they produce their product. Then another challenge is enforcement. This is a crucial part also, enforcement of their product, because this is beyond, I can say, is quite difficult because it's beyond, I can say beyond. This is more on, trading environment or trading or trade environment. So it's hard to for us within MIPO to monitor. So we always ask our enforcement badly, I can say badly. We always ask our enforcement to assist us to monitor. Is there any copycat product? GI copycat product in the market, for example. Then keep everything is how to deal with, and also we ask the enforcement division, our ministry, to assist the shareholder. What they are supposed to do is they are face this problem. And number four, I want to challenge is to create the association. Like I mentioned previously, some GI community don't have any associate in their place. So it's because they are very, level of education, and in the certain area, only all the people doing the things. The young people go to town, come to big city to work. Then they are left the older one in the village to produce to be as a farmer over there. And then number five, level expert. Currently in Malaysia, not everybody that involved in IP, for example, have skill to write we call it a GI book of specification. Even, sorry to say, even our agent, not all. Less than I know, not all, because last time we just introduced, we call it technical specification. For us, when we talk about technical specification, it's not enough to give us as a good detail for GI. So within 3 or 4 years back, we introduced book of specification because we try to up our local GI to the international by introduce this. So for the time being, I'm as a GI officer still do a class to our agent to share our knowledge to them, how to develop a book of specification, how to collect data, how to do a research. For example, how to interview the local GI owner, or how to deal with government of the city or government or state government, how to get a certain, a lot of things. here we have a lot of things to do in terms of document. Yeah? Okay, number 6. Among the detail involved or in GI, the most important public writing. Yeah. Again, book of specification, how to writing the application and GI is correctly. Yeah? This is the crucial part. So this is the issue that so far we are faced after we introduce our new GI Act. Yeah? And the solution, of course. Again, our task as the guardian of angel for IP in Malaysia. Yeah? We also do aggressively awareness. Yeah? Then this year we introduced a GI tour program. Yeah? Myself and my team will travel all over the country. Sorry, to identify the potential GI product, and we try to meet the so-called potential GI holder. We try to get the data, and yeah, at the end of the day, our ultimate goal is try to register it with my pool. And number 2, in addition, we do also the internal and external training intensify. So more internally, so more our officer, my officer, are involved in terms of GI registration management. So far in our division, and not so 1 or 2 officers involved in GI registration management. Number 3 is external training for GI holders and all GI holder representatives. In terms of management, GI registration management, and GI commercialization management. And number 4 is to work with trade organization to promote the GI product, and we try to propose to our federal government to make it as a national project so far. And also number 5 is to providing IP fund. Yeah, we have some IP fund this year, and we also do some allocation. Some allocation, how many thousand? 8,000, if I'm not mistaken. Yeah, we allocate some of this fund to help GI owner if we feel that they don't have money to pay for the registration fees. We help them to we sponsor them to register their GI with us. So this is 5 solutions so far that we do in currently for this year in our office. Okay, certain activities. Okay, for the activities, this is the activities that recent that we do. First, yeah, this is some picture. Like I always mentioned, seeing is believing, right? So this is some picture when we do a meeting session, discussion session, when we develop regulation and geographical guideline. We stay back until 2 o'clock in the morning, and 12 o'clock in midnight. 12 o'clock in the midnight, and some day 2 o'clock in the morning, early morning. Yeah, after midnight, we stay back to discuss, to do whatever we can do to develop this geographical education and regulation guideline and the guideline. Okay, we also do some interview. You see my face over there. This picture that we do an interview with our Mr. Lim. Mr. Lim is a durian owner orchard or durian farm that located in Raub Pahang. This interview, we want to get latest information regarding the GI, the durian itself, because you can see in our list we have product GI, namely durian Musang King Malaysia. So this is some picture. So we also have we call it Tembaga Terengganu. Terengganu is one of the state within Malaysia. Tembaga stands for Cooper, right? This is and we are blessed because this GI owner being supported by our Sultan. Sultan means the king, Terengganu king. So it is more easier when the Sultan Foundation involved. more easier to discuss and to get some information, because they are very eager to register, because this GI is represent Terengganu, because the GI is represent the Terengganu state. Okay, and also this is one of the picture when we send. We have a certificate submission ceremony, because we pass or we give we submit the certificate to our to Terengganu Sultan himself. This is some picture. This is just a picture. Okay, this is for Perak State Carnival. This is some of the GI from the state of Perak. Abu Sayung, Pulau Tiga, Potri, and Perak Gold. Okay, this is me. And also this is a catfish from Pahang, also from the this is from Sarawak, gula apung syrup. This is from Bacalalat, Adan rice. You see the paddy field for that. This is how I go there. 140 kilometers off road. This is a kite kapal. And this is a bungalow charcoal. Yeah, how to charcoal being produced. Okay, thank you. Okay, that's all for me. Is there any question? You feel free to ask. If not, I pass back my presentation to the administrator. Thank you.
Thank you very much, Raizul. There are a couple of questions, but I will read them later after the presentation of our colleague from Thailand. So our next speaker will provide us with thank you very much. Our next speaker will provide us with updates on the latest developments in the GI protection in Thailand. And I would like to call on Ms. Jitima Klinsuan, a trade officer from the Geographical Indications Office of the Department of Intellectual Property of Thailand. Jitima.
Hello, everyone. Let me share my screen. I am Jitima Klinsuan, trade officer from the Department of Intellectual Property, Ministry of Commerce of Thailand. And I know that we are behind the schedule, so I'll try my best to finish it on time. In this session, I am going to give you information about the latest developments in the protection of geographical indication in Thailand. There are three main objectives of establishment of the GI law. The first one is to prevent the public from being confused or misled as to the true origin of the goods. And secondly is to establish the system of geographical indication. And lastly is to prohibit the use of GI in a manner that may cause the public to be confused or misled as to the true geographical origin of the goods as indicated in the registration. Therefore, we established the law, the Geographical Indication Protection Act 2003, together with the Ministerial Regulation and Ministerial Notification, as well as the DIP notification. According to our law, the definition of GI is a name, symbol, or any other thing used for calling or representing a geographical origin and capable of identifying that the goods originating in that geographical origin are the goods, the particular quality, reputation, or characteristic of which is attributable to such geographical origin. As you can see in the slides, there are three main elements of the GI. The first one is the geographical origin, the second one is the goods, and the third one is the linkage between the origins and the goods. This is the registration process of the geographical indication. After the DIP receives the application, we will have 120 days for the examination. If there is anything to be corrected or more information is needed, it will send back to the applicant for the correction. And once it is completed, it will be approved and sent for the publication for 90 days. After 90 days, if there is no opposition, it will be registered as GI. And the term of protection for GI in Thailand is indefinite and no need for the renewal. As for the statistics, as of June 2023, there are in total of 205 GIs protected in Thailand, which consists of 187 Thai GIs from 77 provinces and 18 foreign GIs from 9 countries all over the world. On the left side are the examples of Thai GI products like Phuket Pearl, Pula Chiang Rai Pineapple, Chiang Mai Celadon, and Phetchabun Sweet Tamarind. And on the right side are the foreign GIs, which are already protected in Thailand. There are Parmigiano Reggiano, which is the cheese from Italy, Higashine Sherry from Japan, and Champagne from France. As you can see in the examples, there are 3 types of products that are eligible for protection. The first group is agricultural products, like fruits and vegetables. The second group is handicrafts, like potteries, silks, and cottons. And the last group is the industrial products, which are like teas, coffees, wines, and spirits. Besides the protection of GI, DIP has 3 main duties of the promotion of GI, as shown in this diagram. The first task is the registration. We promote the registration of potential products from all over the countries to be a GI, and also assist with the GI registration process. And we also support the registration of Thai GI in the foreign countries. The second task is the quality control. GIP supports the producer to establish the quality control system, both in self-control level and also the local level. And as for international level, we support the budget for hiring the certification body to certify the products, whether it is comply with the product specification as indicated in the registration. And the third task is the marketing and promotion task. We create opportunity for the producers to expand their markets. For example, we cooperate with the supermarket and modern trade stores to establish GI corners in the supermarket. And we also support the product and packaging development to make it more attractive to the consumer and also to add value to the products. In this part, I will provide an update on the development of the GI law. As of now, many of you may know that the GIP is planning to amend the Thai GI Act because this is the 20 years that we hold this law. So we think it's time for the review. So the objectives of this amendment, firstly, is to enhance the control mechanism to ensure the quality of the products and its traceback system. For example, we're going to require the applicant to establish at least a self-control system before they apply for the GI, and also allowing the officers to inspect the products. Secondly, we would like to make it more compliant to the TRIPS agreement. For example, we are going to redefine the definitions, illegalize any use which constitute to an act of unfair competition, and also use in translation to make it more clear and concrete. Thirdly, to speed up the registration process by shortening the publication period from 90 days to 60 days. And fourthly, to enhance the GI scope of protection, like the protection against a becoming generic. So this is the updates, the current status of our amendment process. The DIP is currently holding the meeting with the GI Law Amendment Committee to gather all the comments and opinions from stakeholders in drafting the new GI Protection Act, which the committees consist of the experts from various fields, including the laws, production standards, agricultural products, rights and sales, and also representatives from the producers. And these are information and updates on the latest development of the protection of GI in Thailand. Thank you very much. And if you have any questions, please feel free to ask. Thank you.
Thank you very much, Jitima. Maybe I can direct the first question to you. One
Yes.
quick one, and then another question for the other speakers as well. When do you expect the new law to be in place, more or less?
It is quite difficult to say because as of now we are in a process of gathering opinions and comments from the stakeholders, but we expected that the first draft of the law will be finished by this year.
Okay, thank you. So the next question is directed to all the to you, to Raizul, and to Katarina. So in cases of internal conflict within the association or the group of the organization that's applying for or is a registered owner of a GI name, is there anything in the law or in the rules that provide for procedures for settlement or dispute resolution so that this internal disputes are resolved? For example, if there are conflicting claims with respect to technical specifications, and in case there are some aggrieved producers who were not part of the process of applying for the GI. Maybe we start with Jitima, and then Katarina, and then Raijun.
Well, according to the question, if there is internal conflict between the producers, do we have any dispute resolution? In our law, it doesn't state about the dispute resolution among the producers, but we do have some practice about these conflicts that we, in every provinces in Thailand, we established a provincial committee, which consists of the representative of the producers of GI and also the government agencies in that provinces. So if there is any conflicts or they need to discuss, our committee will arrange the meeting and let everyone gather and give comments and opinions. And if they decided to modify the registration or there is anything to be corrected in the registration, they will send it to the GIP, and then we'll find out by the GI committee, which will hosted by our ministry.
Thank you. Katarina, please.
Yes, at the EU level, we don't have any committee that would be directly responsible for solving the potential disputes between the applicant for GI and other producers. Ideally, if there is any dispute, for example, about the product specification, these disputes should be resolved before the application is submitted to the Commission. But once the application is submitted to the Commission, what we do in the European Union is that we run the opposition procedure. So after the application is published in the official journal of the European Union, there is the opposition procedure for 3 months, during which the national authority from the EU member state or any physical or legal person that has a legitimate interest from third country can submit the statement of opposition. And then after the opposition procedure, the Commission basically investigates the validity and if everything was submitted in the correct form. And then it's the Commission who basically puts together in the contact the applicant for geographical indication and those people or companies that somehow opposed the geographical indication registration. And these two should engage in the discussion, and they should come up to the solution, which should then be communicated to the Commission, who decides then about the registration.
Thank you very much, Katarina. Raizul, what about in Malaysia?
Okay, if in the Malaysia context, is there any dispute between, let's say, we have two association within the place? Actually, we are not so involved in their dispute because, for example, if they are NGOs, we have ROL, registered or society. If they are association, we have also the ROS. And they are the we call it the organization that register under Companies Act, for example. So they need to refer the companies here or companies what we call the Suruhanjaya over there to resolve their problem. In our part, as a MIPO, we are not really involved for to settle or to be a middleman to settle their dispute, for example, so far.
You have to hire lawyers, I think.
Yeah, that's the way. That's the way. Yeah. Because this is a dispute between them. We are not involved. That's our stand for the time being.
Okay. Thank you very much, Raizul. And this next question is for Azrul. Okay. So in case of any product counterfeiting, is there a procedure to report these instances of counterfeiting? And who can report and where can they report? Are law enforcement agencies familiar with GI?
I think, like Mr. Raizul was saying, we are still engaging the law enforcement authorities to be familiar with the GI provisions in relation to the enforcement. So you have to be a registered GI in Malaysia to make a complaint to the enforcement agency, which is the Ministry of Domestic Trade, kan, Encik Raizul? Yeah. Yes, so you usually can either do it when you represent yourself to the enforcement division, or you can hire like lawyers or agents in Malaysia to make the complaint on your behalf. But in most cases, with the Ministry of Domestic Trade, you would have to do the groundwork as well. With your complaint, you should have some investigation report or track purchase to show why you have reasonable belief to think that there are offences committed pursuant to the GI Act. So once this is provided to the enforcement division, I think for now, it's really good to engage the enforcement division to familiarize themselves with the new provisions of the GI Act so that they can, know what is it that they have to look out for. And they are very used to initiating actions under the Trademarks Act and the Copyright Act. So I think it's just a matter of increasing the knowledge to also put the GI under their radar as well, to distinguish between what is a trademark and what is a GI. But the good thing is, if you are a registered GI owner in Malaysia, you just have to look at the certificate and you just go on from there. So that's going to be what is going to be very helpful. So apply more to Malaysia.
May I add some?
Thank you.
May I add some?
Yes,
okay.
Sure, Raizul.
For information, for this year, we currently we have a several series discussion and gathering and sharing information with our enforcement division. And we will meet them on August for the 5th session to discuss to discuss regarding the GI specifically, and also to get the information from the ground, what their point of view, from the enforcement perspective. So this year we are active to have a series of discussion with our enforcement law division in our ministry. Thank you.
Thank you very much. The next question is for Katarina. Do agricultural products need to implement, or I suppose this would be for the GI owner. So is there a need to implement a traceability of agricultural products?
Yes, absolutely. The traceability is crucial for geographical indications, for ensuring the safety and quality control, but also the essence of geographical indications lies between the product, the quality and specific characteristics of the product that comes from the geographical area where the GI is produced. So basically the objective of the traceability is to ensure that at any point where the product is put on the market, we can trace the origin of the product. And for this purpose, it's the producers who should have in place the system for traceability, which in practice means that they need to keep the documentation, they have to have in place some record keeping and identification. So when the control authority in the member state or in the third country comes to control the GI producer, he or she is able to submit the relevant documentation, which enables control authority to identify the origin of the product.
Thank you very much, Katarina. The next question is for Jitima. Does BIP Thailand have any promotion and marketing of Thai GIs abroad?
As I mentioned earlier, that we cover it with supermarket, and in terms of international market, we do bring our producers, potential producers, to the international trade fair. Last month in May, we participated in the ThaiPex, the International Food Expo, the biggest one in Asia, to do the business matching with the international buyers. And another example is we also have an activities through the social media. We have the Facebook page of GI Thailand and also YouTube channel to promote our GI, not just only for the marketing, but also to create awareness of GI among the consumers. Thank you.
Thank you very much. I'd like to go back to Katarina for the next question. It's a bit of a long question. This relates to existing rules for GI protection and the predatory and parasitic practices of the misuse of GIs in the domain name system. So even though the domain name is false or is an unauthorized use of a GI name, won't this constitute a violation of existing rules? Because there is actually no relationship between the domain name and the good. Is there something in the EU in the rules that would can be used to prevent this?
It's a bit of a complicated question. I'm not sure if I understand correctly what the participant is asking, but at the moment we don't have any rules at the EU level that would be guiding the abusive registration of geographical indications in domain name system. And also, when we talk about the domain name system, we have to differentiate between the domain names that are so-called generic, for example, .com. And maybe I can use the example. If someone registers the domain name www.champagne.com, in this case, if the producer group from France thinks that this is the abusive registration, what they can do, they can contest this only in the court, or there is the specific procedure that is run by the ICANN organization, which is responsible for the global governance of Internet. And this is the UDRP, Uniform Dispute Resolution Procedure. But the problem of this procedure is that it is limited only to trademark holders. So unless the champagne producer group is also the holder of trademark, they cannot use this UDRP procedure. And when we look at the EU level, there it depends on which domain name from which member state we are looking at, because the rules for country code top level domain name can be defined at the national level. There, the ICANN organization, we use some freedom to member state. And there we see the varying situation, because there are registries, for example, at the .eu, there is the dispute resolution procedure, which recognizes geographical indication. So if someone abusively tries to register champagne.eu, the champagne producer group can use the available alternative dispute resolution procedure because the geographical indication is recognized as the ground to open this procedure. But in any case, there are rules that have to be, or the elements that have to be proved in order to either get the domain name cancelled or either get it transferred. And so in most of the cases, the person who opens the dispute must prove that the domain name is confusingly similar or identical to geographical indication. They have to prove that the person who registered the domain name is not the legitimate holder or doesn't have any legitimate right in GI. And they also have to prove that the domain name was registered or is being used in the bad faith. And what I was talking about this in my presentation, what we are trying to do with our current proposal is to harmonize rules at the EU level, because that's for us the only level where we can act. I hope this answered the question.
Thank you very much. Well, we're actually out of time, but I have a couple more questions, quick questions. So I will read them, but for those that I will not be able to read, we will send an email to the participant. The next question is for Raizul. Is there a fee to update the GI specification? And who and how do you do the control, traceability, audit, and monitoring of GIs in Malaysia?
Okay, yeah, we have in Malaysia, you want to make some amendment in terms of GI specification, you need to apply by using the form GI A2, GI A2, and the fee involved is Malaysia ringgit 100 ringgit, 100 Malaysia ringgit. Then you also need to finish us the detail, what the thing that you want to update in terms of specification, not just information, but any technical or any the proof evidence that when you update it, you need to put some of course information and evidence. Yeah? Because let's say for example, let's say you mentioned to us in the books. You are arrived at a certain area of the quality, and you need to furnish us, let's say, recognition from the authority to show that the quality that you achieve is proven or recognized by the authority. This is the thing. And then who and how do you control traceability audit? Okay. For the time being, yeah. For the time being, we are not so, because we are still in development in terms of registration, so we are not too strict. Normally, we go from time to time, we visit them sometimes, and then we also, collaborate with the certain, for example, Ministry of Agriculture to check. Because sometimes the farmer is also involved with the Agriculture Ministry. So we contact the agriculture division, for example, for the rice. Yeah, for the rice division, we ask them certain information. For example, is that the area that been registered under GI still exists? Yeah? And how about the quality? Is that down or maintained, for example? And also from time to time, we also involve with the state government. Ask them. Because all the farmers, all the GI provinces normally being controlled and monitored by the state government in Malaysia. Yeah? So we ask the respective officer. Right? And if we still not satisfied, yeah, we go and visit them directly. This is the thing, because in terms of audit and also traceability, we leave to the market itself to control. Is from our side for the time being. Thank you.
Okay, thank you very much. Okay. We have last 3 questions more. Maybe we can answer them quickly. So this one is probably for Jitima. What is your government policy to encourage GI registration?
We believe that registration of GI is one thing that can add value to the products. So we arrange the activities of our office, go to the provinces, to the communities to talk to the producers of the potential products that what is the importance of GI protection, how to register it, and what they are going to get after registration to help them do the application, as well as we also cooperate with the universities in that provinces to let them be the consultants of the registration for the producers. So we would like everyone to know about the importance of registration and to know what they are going to get for the registration. Thank you.
Thank you very much, Chitima. Okay, so maybe I can ask this question to Katarina and Azrul. We should be able to identify any cases of GI infringement. How are they identified, and what actions are taken? Maybe Azrul and Katarina, and then the last question is for Raizu.
The controls and enforcement of geographical indications are in the competence of the member state authorities, the control authorities. So it's the control authorities of member states who have to verify the compliance of GI products before they are put on the market. And also afterwards, when the GIs are already in the market, the competent authorities have to do the continuous control if the GI name is used correctly and if the products that are used in the GI names are in compliance with the product specifications. So most of the time it's the competent authorities that find some infringement. And what is typical is the use of GI name on the products that are not produced in compliance with the product specification. So, for example, someone produces the cheese, and they will use the name Parmigiano Reggiano on the GI, which is the Italian GI, but the product doesn't comply with the attributes. Or what we also see is that sometimes they use Parmigiano Reggiano style, and geographical indications are also protected against this kind of infringements. So once this is found on the market, for example, the customers or the consumers can notify the competent authority. It's the responsibility of the competent authority to take the control and to verify if the product is the real GI or not. And it's also the responsibility of the competent authority to take the appropriate measure, which can be either the withdrawal of the product from the market, or if it is some small infringement, then it's basically putting the actions into place that will bring the product in compliance with the product specification. This might be, for example, in case there is some small mistakes in case of labeling.
Okay, so in Malaysia, this information will usually be provided by the complainant. So it would be the owner of the GI. They would usually give a representative would give a statement to the authorities to indicate what grounds do they believe that these products are counterfeit or otherwise. So usually it will be from the person who has the knowledge, because it's going to be a criminal proceeding. So information would have to come from the person who has the knowledge to tell the difference. Yeah.
Thank you very much, Azrul. And finally, Raizul, last question. How does MIPO promote and support national GI products?
Okay, in terms of promotion, we are encourage them. Let's say when we go to, let's say we always send our officer and our, not from MIPO, from the various ministry and division, we encourage them to bring our flyers and list of product of GI throughout, go to the overseas if they attend the training, or attend the seminar or conference or whatever. Secondly, for the GI owner is we encourage them, we matching them with the certain, for example, government or funder that have provide grant to them for them to develop their product. Because if they just have a certificate only without nothing, it's nothing for us. So what we try to assist to give some assistance for them is we match them with a certain, for example, in our ministry we have a business development division, and this division may help all the GI owner to develop their business by using the GI product. This is the thing. Another thing, we are matching them with another Ministry of Trade, maybe to develop or to bring them with their product overseas to attend the expo of business conference or whatever. This is the thing we MYPO can provide for the time being. And another thing, in terms of policy, I read that what policy the government use to encourage GI registration. Of course, we have a national IP policy year 2005. Malaysia have a national IP policy year 2005. From there, we develop our framework of a GI Act and GI procedure, and also we develop our development. We have a 10 years plan for GI. Yeah, and from there, there's a lacking everywhere, but the plan is planned. But slowly but surely, we promote our GI by using that plan. Then we also review and do some tweaking in our plan. That's from now, from us.
Okay. Also, thank you very much. That was our last question, and but there were a lot of questions in the audience. They were very interested in all your presentations. So I'd like to thank all of you, Jitima, Katarina, Azrul, and Raizul, for joining us this afternoon in this workshop on geographical indications. And I would also like, on behalf of the IPKey Southeast Asia Project Management Team, I'd like to thank all of you again, and of course, the participants. And I would also like to thank the interpreters and the technicians, and of course, my colleagues at the IPKey Southeast Asia. Thank you to all of you.